10 common DWI myths debunked, what you need to know before it's too late. DWI, or driving while intoxicated charges, can be confusing and intimidating, especially when misinformation clouds your understanding potentially of the law. Believing myths about DWI can result in poor decisions and severe consequences. This video debunks 10 of the most common DWI myths to help you separate fact from fiction and stay informed. For every video in this series, there's additional videos that expand on the various topics that we discuss. Myth 1. You can't get a DWI if you're below the legal limit in Texas. Here's the fact. In Texas, a BAC of 0.08% is the per se legal limit for intoxication. However, you can still be charged with a DWI if your driving is impaired due to not having normal mental or physical faculties, even with a BAC below the per se legal limit. Officers can base these charges on observed impairment and field sobriety test results. Myth number 2. Refusing a breathalyzer test will prevent a DWI charge. Here's the fact. It does not guarantee that you will not be charged. Under Texas's implied consent laws, refusing a chemical test can result in automatic license suspension and be used as evidence against you in court. However, it may be better for you to actually refuse the breathalyzer. Depending on the jurisdiction, the officer may or may not apply for a blood search warrant. Even if the state gets your blood due to the officer obtaining a search warrant, these cases can still be won. Learn more about your rights and what to do in these situations in my video on implied consent laws and what they mean for you. Myth number 3. Drinking coffee or taking a cold shower can sober you up quickly. Here's the fact. The only thing that lowers your BAC is time. Coffee, cold showers, or other quick fixes, they might make you feel more alert, but they won't eliminate alcohol from your system. Myth number 4. You can't be arrested for DWI in a parked car. Fact. Here's the reality. You can still be charged with a DWI if you're found in a parked car, especially if the keys are in the ignition, the car's in drive, and or the engine is running. Texas law focuses on operating a vehicle, which doesn't always mean driving it. Despite the name, driving while intoxicated, you don't have to be driving to be charged with this offense. Myth number 5, field sobriety tests are objective and cannot be challenged. Here's the fact. Like the horizontal gaze nystagmus, walk and turn, or one-leg stand, they are subjective and can be influenced by factors like medical conditions, nervousness, or even the surfaces that you're being tested on. It is challenging for people who don't have any intoxicating substances in their bodies to successfully perform these roadside theatrics. Officers are trained that the eyes don't lie for the horizontal gaze nystagmus, but in fact, the eyes can create the impression in the officer's mind that the person is intoxicated, when in fact, there's a medical reason why nystagmus, the jerking of the eyes, is present. Sometimes the HGN test isn't administered correctly, and the very nystagmus officers are looking for is caused by the poor administration of the HGN. For a detailed explanation, check out my video on the field sobriety tests explained. Myth number 6, you can't get a DWI if you're driving on private property. Here's the fact. In Texas, DWI laws apply on both public and private property. Operating a vehicle while intoxicated on private property, like a driveway or a parking lot, can still result in a charge if the public has access to the area. For example, a department store parking lot is privately owned, but the public has access to the area. Operating a motor vehicle while intoxicated in this example could result in a DWI charge. Also, sorry to say, there's no such thing as home base. If an officer sees you operating a motor vehicle in a public place while intoxicated, driving home doesn't prevent an arrest or charge. If you evade the police in a motor vehicle, you could also be charged with felony evading, a third-degree felony. Myth 7, a first-time DWI isn't a big deal. The fact is the exact opposite. Even a first-time DWI carries serious consequences, including fines up to $2,000, up to 180 days in jail, and your driver's license suspension for up to 2 years. The long-term effects, like increased insurance rates and a permanent criminal record, are also significant. Myth 8, breathalyzers are always accurate. Here's the fact. While breathalyzers are commonly used, they are not foolproof. Factors like improper calibration, certain medical conditions, or residual mouth alcohol in your mouth can result in inaccurate readings. Myth number 9, prescription drugs won't lead to a DWI charge. Here's the reality of it. Even legally prescribed medications can impair your ability to drive and result in a DWI. If a medication comes with warnings about drowsiness or impairing your motor skills for that potential, it could make you legally unfit to drive. Myth 10, you don't need a lawyer for a DWI. Here's the fact. A DWI is a serious offense with lasting consequences. A skilled criminal defense attorney near you can challenge evidence, potentially negotiate reduced penalties, and help protect your rights. Representing yourself increases the risks of harsher outcomes. If you attempt to defend yourself, you are going up against an attorney for the state who has gone through law school, studied for and passed the bar exam, and possibly knows the rules of evidence far better than you. A heart surgeon doesn't do heart surgery on himself or herself. You are investing in your future by hiring an experienced attorney to defend your rights and test the state's evidence. Believing myths about DWI can lead to costly mistakes and unnecessary legal trouble. The best way to navigate these charges is to stay informed and consult with an experienced attorney. If you've been charged with DWI, don't face it alone. Call today for a criminal law expert that can lead you and guide you through this process. Don't do it alone.